Good afternoon, everyone. I am Attorney Wilda Pomales at the Meredith Nagel Legacy Legal Team firm, and I am the family law attorney here. And so today we will be talking about our different services. If you have any questions, we'll wait a couple of minutes as people are logging in. Feel free to just submit your questions, and then I'll be able to answer them as we go along, or we can do it at the end. And then as we get more people in, we'll be able to discuss, have more of an open-ended questions. And today I'll be talking about unbundled services. And then if we have some more time, I'll go into alimony. I've been getting a lot of questions regarding the statute change as far as the alimony goes. And so we'll be discussing that as well. So just want to thank everyone for joining us here this afternoon. And then, as I said, if you have any questions, feel free to put them on the chat or give us a call afterwards. And then we'll be happy to answer any questions that go unanswered. So again, my name is Wilda Pomales. I am the family law attorney here. I want to let everyone know that one of our questions that we get when we get consultations with divorces, paternity cases, or even modifications, and modifications come after an order has been entered, a final judgment has been entered, and there are some changes, some substantial changes, and people want to get that modified. And so we get the consultations done, and a lot of times there are different phases that you're in your case, and our leads or our clients are wondering if we're able to assist them, even if we weren't the original attorneys that represented them in the case, or if the case already has been going on and we weren't the ones that started with the representation at the beginning. And some of the questions are, can you still represent us? And yes, our firm can jump in at any point in time that you're in your case. Sometimes, of course, if you're waiting too long and you're getting ready to go to trial, it may be difficult for any attorney to jump on in because they haven't been prepared with the facts of the case and the discovery process and the deadlines that need to be followed. But if you're starting a case or in the middle of a case and you just need some limited representation, so we call it unbundled services or limited scope representation, then we can definitely assist you. What that looks like is you're choosing what we represent you in. And so part of the divorce process or a paternity case is mediation, for example. And so before you can even get to a trial, you have to go to mediation. And so from the time that you file your petition and do the discovery phase to the time you go to mediation and get mediation scheduled, that could be maybe 3 to 6 months. And so sometimes you're able to carry the case on your own without having legal representation because it's the paperwork, it's the submitting of financial documents, exchanging it with the other parties, and you're able to do that on your own. But then it comes time to go to mediation and you don't want to go to mediation unrepresented, or you don't know the legal aspects of the agreement. And so you can give us a call. We will give you the quote or the retainer of what is needed to represent you for mediation. And it's unlike a full representation, it's limited to just our appearance or our representation for mediation. And so whatever that entails for your case. And every case is different. Not every case is the same. And so some, depending on the issue, whether it's a paternity case, a divorce case, or a modification, it might depend on what is needed to get prepared for mediation. And so all that will depend on and will come out during our consultation, and we will be able to let you know how we can assist and what the fees will be for that. And so the benefits of getting unbundled services or limited scope representation is that you control what the attorney is representing you in and how involved the attorney gets. It can be cost effective because you don't have to have an attorney on retainer doing that discovery process, exchanging the documents if you're able to do that on your own. And so you're able to get legal representation when it matters and when you're stuck with those legal jargons, and just pay for that simple task or whatever that scope may be without having to expand on a full representation, which can be very costly when you're going through any type of legal situation. And so Also, sometimes the other options that our clients need is they go through mediation, because mediation is with the mediators, not a judge, not any type of court personnel that would hear your case at the end, right? It's not a general magistrate or any of that. So the mediator is just a neutral party. And so sometimes the parties take themselves through that process on their own without being represented. But then if there is no full agreement, then they have to go to trial. And that's when the judge decides what will be the outcome of the case. And so after that mediation process, sometimes the clients come to us and ask if we can represent past mediation and going into trial. And yes, at that point, again, depending on what the issues are in the case, we will assist you and get prepared for trial and take you through trial. And so sometimes what happens is that in mediation, you're able to get into partial agreements. And so if you are going through a divorce, for example, you have children, you have property, there will be a marital settlement agreement that needs to be entered. There is a parenting plan that needs to be entered. And so sometimes you can agree on the timeshare with the children, the child support, but not on the property, not on the sale of the property, the split of the net proceeds. And so at mediation, you will execute a parenting plan, but not a marital settlement agreement. And so when you go and get prepared for trial, you'll only need to get prepared regarding the issues for pertaining to the marital settlement agreement. And so that is something that we can assist you with. And at that time, you're only expending on funds to have us, our firm, represent you through trial for those specific issues. And so it can save you a little bit because we're not having to prepare on every issue, which at the beginning of the case, we would have had we represented you from the beginning. And so with that, I also want to go into, we've been getting a lot of questions regarding alimony. And so there was a change in the law. And so what happened is that the statute changed to change the terms or the length of marriages. So we have a short term length of marriage in the state of Florida, we have moderate, and we have long term. Prior to the change, short term was marriage that lasted from year one or from 0 to 7 years. And then the moderate marriage was from 7 years to 17 years. And then anything above 17 years was a long term marriage. Now, since the change of the statute, a short-term marriage is from the beginning, the date of marriage, to 10 years. And so anything within that range is a short-term marriage. Anything between 10 years and 20 years is a moderate long-term marriage. And then anything above a 20-year marriage is a long-term marriage. The other change was that permanent alimony is no longer available. So you cannot get an award of permanent alimony. The other ones are still effective, durational, bridge the gap. You still have rehabilitative. You still have certain alimony terms that you can get, but you can't get permanent, no matter the length of marriage that you have. And then also another change is the amount of alimony that you're able to receive. And so with the short-term marriage, and now these are the marriages that lasted from the date of marriage to 10 years, you are able to receive 50%, the maximum amount of time. And all this, again, you have different factors that the court will look at to determine where you fall, right? And so depending on the marriage, the length of the marriage, the income of the parties, all those different factors, whether one was a stay-at-home parent versus the other one working full-time. So all those factors the court will determine. But when you're looking to see what the maximum award that you can get for alimony, the court will look at that length of marriage. And so for a short-term marriage, the most you can get is 50% of the length of marriage. So if you're married for 10 years, the most you can get in length of alimony is 5 years, 50% of the marriage, 5 years. And so the court can award you up to 5 years of alimony, whatever that amount comes out to be. And so when you have a moderate length marriage, which is 10 years to 20 years, you can get up to 60% of duration of alimony that you will receive. And then again, that amount will vary. And then any marriage that is long-term will be up to 75% of the duration of the marriage. And so that is where the major changes occurred, the duration of the marriage and determining how much duration of alimony a party may get awarded, putting those specific percentages in place so that there is no longer that permanent animal award. If you have any questions, feel free to definitely let us know. We can have a consultation, see what the facts of your case are, and that way we can determine what it is that you may be eligible for. During consultations, we're not able to say what the amount is because that will take the actual process and us analyzing actual financial documents to be able to determine what is that amount that I will receive. It's not as easy as saying my spouse makes X, I make Y, and then this is the amount of alimony. Other factors that come into play are also the child support. So if you guys have children, if the parties have children and there is a child support that needs to be calculated, that needs to be calculated, and then the alimony amount will also determine what that child support amount will be after alimony is calculated to determine any of that. And so those are the changes that have come up. And so people are wondering what will happen to my existing alimony order. And again, for those you would need to, every case is different. There are no two cases that are the same. And so we would need to determine what was the order that was previously entered, or the final judgment that was previously entered in your case, whether it's a divorce or a modification. And so based off of that, if somebody is trying to modify, sometimes with changes in statutes, parties try to modify to say, okay, there's no permanent alimony and there was an award of permanent alimony through a final judgment. I want to change it. And so the person that's paying the alimony may want to cut that and say, I no longer have to pay permanently. So let's change that. And so depending on what the final judgment state, that modification can be done. And it's not an automatic change that the court is going to review all these cases and say, okay, no more alimony for some people that were awarded permanent alimony before, or make those automatic changes. And if you have any questions or ever in doubt, definitely feel free to give us a call, get a consultation at our firm, and then we'll be able to see and review that final judgment, that final order, and determine what are the possibilities or what are the different options that you may have. The same goes with any type of child support cases. Sometimes it's been 3 years or more since the child support order has been entered. And so some clients are seeking to see what their options are now that incomes have changed. Maybe somebody has lost a job or had an increase in pay. And so you're wondering, what are my options? And so those are different things that we can sit down with you and just say, go back to our unbundled deals, and you don't have to retain us for a full representation. We can limit the scope of our representation just to review your final judgment or a final order and let you know what options exist. And then we can guide you, and then you can determine from there on if you hire us as a full representation or get us to just do a limited scope. We also do, within the limited scope, you can do just drafting. And so if you're able to take yourself through that legal process on your own, we can draft the documents for you to get that process started. And whether it's, again, a divorce, paternity, a modification, we can draft those legal documents for you. You know that they've been done by legal counsel. And so you just submit them to the court on your own and then represent yourself through that process. And then if you need us further down the road for mediation again, let's say, for example, then you can give us a call back and then say, okay, we need we need your firm to represent us for mediation, and we can get started on that representation as well. So at any point of time, you can hire us and we can be one of those one-off representations where it doesn't have to be for the full thing. Or if you have any questions, again, those could be limited to just a session, just a consultation, and you do not have to pay for the full representation. And so let's see if we have any questions here. If you guys have any questions, feel free to let us know. But I think those are the changes mainly that we have been seeing recently with the modifications and the Adam case since it changed. So one of the questions here is that if there is ever a situation where I wouldn't need an attorney for a divorce, we don't recommend that you ever go without an attorney because you don't know how to legally draft documents, right? And so there are agreements, like I said, if you have children involved and part of the divorce, there is going to be a parenting plan and a marital settlement agreement. If you don't have any children, then there will only be a marital settlement agreement. And so oftentimes we have clients come to us because they go through the process on their own. They draft the document on their own. They submit it to the court. The court enters a final judgment because both parties agreed to it. They were both self-represented. But then after the final judgment gets entered, one party is not doing what they were supposed to, right? What they had agreed to. And so when the other party tries to enforce it, it's something that the court cannot enforce because the language does not exist within that agreement. And so a lot of times you think you're in agreement and you're not thinking through of what the possible disagreements could be in the future. And so that's where our firm can assist you with letting you know, okay, even if you do have an agreement, we're going to draft it in a way that if there was a disagreement in the future, you're able to enforce that document and it's not just an empty order that you're unable to enforce. It's unenforceable at that time. Because what happens at that time is that if the court cannot enforce it, then you're going to have to modify it to make sure that language gets added in there. And then a new order is entered. And so that you have clear language in there. And that makes the process a lot lengthier because you're having to reopen your case at that time. And then, of course, spend money on representation to redo the process and redo the paperwork. And so even if the parties agree, I always recommend during consultations when clients say, yeah, we have everything and we have agreed on everything, there's nothing that we're disputing. We just want our divorce to be final or our paternity case to be finalized as quick as possible. I always let them know they can hire us just for that drafting process. And that way they know that the agreements and the pleadings have been done correctly. And that way they take it to the court. They can just submit it to the court that way, but they know that a legal counsel was the one that reviewed it and drafted it. And so they will have, or it may limit their issues because we don't know what may happen in the future, but it limits that issue of not being able to enforce it. And so another question that we have is that if you have to reevaluate the divorce settlement or child support agreement, child support, yes, typically when you get divorced and there are no children involved and you only have a marital settlement agreement, then you're agreeing to everything that exists at that time. So who keeps the debt or how the debt gets split, the assets and the liabilities, how that gets distributed. If you have children involved, it goes to the parenting plan, right? And so as children get older, and if you're getting into an agreement when the child is 6 months old, it's going to be very different, or things may change when the child is now in high school or middle school, sports, activities, even the schedule. And so you may want to get that modified. And in order for you to be able to do that, you just draft a new agreement if both parties agree to what those changes are. And you can submit it to the court again, stating you guys agreed, the parties agreed to the new terms, and you want this to be entered into the court system. So it does need to be written and executed and submitted to the court if you want something to be permanent. If it's something that is temporary and you guys are switching one weekend for the other, and it's something that is not going to be a permanent change, then you don't need the court to allow you to do that. You as parents can discuss with each other and you won't have to enter anything with the courts. But if you want a permanent change, then yes, you would need to submit a new document, a new parenting plan, and have the court make that an official order. Accept that. And another question is, could the amount of child support increase as the children get older? Child support is based off of the party's income, the number of overnights, health insurance, which party is paying for the health insurance, if health insurance is needed for the kids, daycare, if daycare is an issue, who's claiming the children for tax purposes, the tax dependency credits. So all that goes into the guidelines for child support. And so whether it increases or decreases as the children are getting older will depend on those factors. And so most commonly, the party's income is what changes. And so sometimes people start earning more, and there may be an increase in child support if one of the parents stays earning the same and the other parent continues to earn a little bit more or gets different positions or switches careers. And so you have higher earning income, then yes, the child support may increase. But again, at that time, we won't know without analyzing what the financials are and determining what everyone's income is, as well as the other expenses that go into those child support guidelines. And so it's not a guarantee. We do have a lot of clients as well coming in asking to modify their child support amount because the order was entered when the child was 5 and now they're in high school and the expenses are more, the car insurance for the child or the car expense for the child. And many times the parent doesn't know what their options are. But yes, you can modify child support if there is a substantial change, if there is an increase or decrease in incomes. And so we can definitely assist you with that as well. Another question is, what happens if we cannot come to a new agreement? Can an attorney enforce it? And so without a new agreement, after a final judgment has been entered, without a new agreement, an attorney cannot enforce anything. Only the court can enter an order to enforce an agreement. And so the court can enter an order determining what those terms are, right? What that final judgment will state if the parties cannot enter into an agreement or you get into an agreement. So without the parties voluntarily entering into an agreement, signing off on it and submitting it to the court, there's nothing the attorney can do at that point. It is just going through the legal process of going through the court system and letting the judge decide once the parties do not agree. And that is, again, depending on what type of case you have. If it's a divorce or a paternity case, then different factors need to be determined, and the judge will have to look at the different factors and the facts of the case to determine what is the best interest of the children, if there are children involved, and enter that final judgment for the parties. So sometimes, unfortunately, what happens is that one party may want to agree, even if you are exercising, for example, equal time sharing with the children, and one party says, okay, let's agree to that and put it on paper and submit it so that our divorce is finalized. And the other party may not want to sign that document. There is nothing that we can do. Even if you have already been exercising that equal time sharing, there is nothing we can do to force that other party to sign an agreement. It will just need to be up to the judge at that point. So let's see if we have any other questions. I don't see any other questions. And again, if you're ever in doubt or ever have any questions as to what your final judgment states or anything that was entered that you may not have understood when you were going through the trial because you were not represented, we can assist with reviewing your legal documents and letting you know what options you may have or what was discussed, what was entered, and what are the obligations of each party after that final judgment was entered. So we don't have any other questions. Again, thank you for your time. And we are here again to assist you, whether it's for a limited scope or a full representation. And we are happy to assist with any questions that you may have.